Greetings, campers, and welcome to today's presentation, the latest in the Canadian Artists Network TELUS webinar series, AI for Artists, the Legalities. My name is Scott Walker. I'm the Executive Director of the Canadian Artists Network. Along with me today is Malia Hudgen, who is working with us this summer as a summer assistant. So she'll be monitoring the chat function today. It is a pleasure to welcome artists from right across Canada to today's webinar. And we've got a lot of first-time campers today, so a special welcome to you. Hope you stick around. I'd like to begin by acknowledging that we live, work, travel, and create on the traditional territories of Indigenous peoples who have cared for this land, now called Canada, since time immemorial. We acknowledge this as part of our covenant with all Indigenous nations to share, respect, and protect the land in the spirit of peace and friendship, and to honor the future generations of all our nations. Well, a few days ago, I was watching a video on YouTube by a music producer and YouTuber named Rick Beato. And if you're interested in the music business, I highly recommend Rick's videos. Rick had AI concoct a fictitious singer, complete with a name and also an image of him. And then he had another AI platform write him a song based on a few inputs that Rick gave them. And then he had a third platform prepare a recording, complete with the guy's voice, the guy, of course, who didn't exist. Well, it wasn't any worse than some of the stuff we hear these days. Rick pointed out that it wasn't very good, and one of his followers threatened to create an AI lawyer and sue for defamation. So at least we can still laugh about this, at least for the moment. But for artists, the legalities of artificial intelligence are no laughing matter. When we presented our first AI webinar in April, the legal aspects kept coming up in the Q&A session, so we thought it'd be a good idea if our expert joined us again to talk about that particular aspect of AI. Now, I'm sure questions will occur to you during his presentation. Please put them in the Q&A box. And now it's time to introduce our presenter. If you attended the presentation in April, you will know him. He is a strategy, marketing, communications, digital, and AI expert with 30 plus years of executive experience. Please welcome back Lauren Solway. Lauren?
Hey, thanks, Scott. And good afternoon, good morning, everybody. It's great to be back again. I find this topic particularly interesting for me. I'm not a lawyer by trade. Both of my brothers are lawyers, but I do run a management consulting group, a boutique agency, and I've been a career marketer for pretty well all of my life. And so this area, as Scott had alluded to, is fascinating, and it's changing so quickly. And so what I'd like to take you through is just some thinking around the implications of AI as it relates to the legal frameworks that are in place today. And Scott, maybe if you'd be okay to start the PowerPoint, that would be great. So this is really interesting. And so as Scott had alluded to, the last time we talked about a lot of the collaborative tools that are available to artists like all of us to be able to make our work even better. But there are some implications, certainly, as AI, it's moving so quickly right now, and it's having a profound impact on trademark and copyright laws. And so a lot of this is being defined as we speak. And so on the next slide, here's what I'd like to cover off today over the next 30 to 40 minutes. And so the implications of AI are pretty profound as it relates to trademark law and copyright law. So what I'd like to do is talk a little bit about how the laws are applied to AI today. And it's a very murky area right now. Maybe review some of the issues that are facing all of us as artists, because it's pretty profound. Talk about content ownership, and this is really at the eye of the storm. Who owns the content? Does it start with the originator, or is it with the person that's actually putting the cues into the AI platform and repurposing some of the work? So we'll talk a little bit about that today. We'll talk a lot about training data and how these AI platforms actually use our content, artist content, to train, and then how that implicates the ownership rights. And then finally, I'll provide a point of view on what I think is going to happen over the next 2 to 3 years in terms of some of the legislative framework being in place to help protect all of us. On to the next slide. So to begin, I wanted to talk a little bit about how AI actually leverages a lot of the work that we do as artists. And so for those of you that don't know, what the platforms essentially do is they'll scrape the web. So they'll scrape the internet and they train themselves. And anything that we post publicly from an art standpoint is fair game today for these platforms or these bots. And so they'll scrape it, they'll take the content, and then they repurpose it, and essentially as their own. And so anything that we make available on public forums right now is open to training opportunities for these platforms. And of course, naturally, this raises a lot of legal concerns and a lot of ethical concerns because it really is a new territory right now. And so the biggest question around this is, if the AI is using original content to train itself, who really owns the repurposed work? Next slide. And so I thought what I would do is talk a little bit about copyright law and trademark law as it exists today. And it's going to have to change, and it is evolving quite significantly as we speak. So today, in terms of how copyright law works, it really protects what are deemed tangible original works that are protected automatically once they're created. So if we create an original piece of art or work or an asset, essentially we are protected by copyright laws, and those laws govern things like distribution, reproduction, monetization, any of those works that are used publicly and used on display, and then what are defined as any derivative works that come off of these tangible meanings, meaning that if there's if someone makes a replication or a duplication of the art and it's slightly different, there is protection in place today. The biggest issue now is that AI, so artificial intelligence, is throwing a new bug into the whole mix right now. So it complicates it quite significantly, mainly because it's a machine that's repurposing the work, and you can't really copyright or protect machine works today, because the biggest question for those that are working through legislative frameworks right now is, who is the artist? Is the artist the AI platform that repurposed the work? Is it the programmer, the coder? Is it the artist themselves that originated the work? Is it all of the above? All of that has to be worked through in terms of the new legal frameworks. Let's take a look now at trademark law as well on the next slide. So trademark law historically was really put into place to protect what are known as brand identifiers. So things like logos, taglines, packagings, names, slogans, even advertising material around a product or a brand, that was protected by trademark law. As long as it was being used for business or commercial purposes, it was protected. The biggest risk right now for all of us is that AI is generating such similar brand identifiers. It can replicate logos, it can replicate slogans, it can replicate taglines. So everything looks almost like the originator, which has a lot of implications around brand identifiers for major brands around the world, like Coca-Cola, McDonald's, Netflix. There's big issues that are emerging from AI-generated outputs right now. And so those are some of the things that I'll talk about in terms of the new legal frameworks that are starting to shape how we can be protected as artists. Next slide. The biggest question right now, both through the European Union in the US and Canada and countries around the world, is who really owns the AI-generated art? And so there's a lot of uncertainty around this today. And a couple of key points that I researched. So the first one is the US Copyright Office. It doesn't recognize any type of artistic work that doesn't have human authorship around it right now. So anything that's AI generated typically does not have any type of protection today. Second point is that works that are generated entirely by AI right now are deemed unprotectable. It's just too gray right now, and the issue around who really has the ownership rights is the biggest issue that's manifesting itself. And then the biggest caveat or governor of all this is the third point, that if human inputs are substantial, the ownership may lie with the user. The big question is, who is the user? Is the user the person that originated the initial artwork that's used to train the AI platform or bot? Is the user or the owner the coder or the programmer? Again, that's what makes it very complicated. I think in a lot of ways, it'll probably be all of the above, and we'll talk more about other precedential legalities that have occurred over the years across other verticals that are probably going to influence the law moving forward. Ownership really hinges on the degree of human input. So the amount of human intervention around any edits, any curation, any prompting that we do to tell the platform what it needs to do to be able to scrape the internet to generate the repurposed art. So the big question here is how much human creativity is really needed to be able to determine who owns the AI generated art. Next slide. So the biggest issue in the heart of the storm is really this whole notion of what's deemed as training data. So because these platforms actually scrape the internet and they use copyrighted content to train themselves and repurpose artwork, that's the biggest issue. And so most generative AI tools don't seek any permission at all today. And there's a lot of lawsuits that are starting to come to the surface that I think are going to have a profound impact on how legislation is drafted into the future. And so some of the controversies around training data are really around the artist didn't give any consent for the platform to scrape their content to be able to use to train the platform. There's no form of attribution or compensation available today to the originator of the artwork. And then finally, a lot of the work that is repurposed by these platforms, these AI platforms, looks so similar to the originals that it has a profound impact on the originator's value, the art value, or the value of the initial artwork that was produced. And so that's where a lot of these legal actions and a lot of lawsuits are starting to surface around unauthorized use of content, original content, to train these platforms. Next slide. So how do artists currently feel? Well, you can probably sit on either end of the continuum. And we talked about this the last time. I talked about some of the AI tools that were available when we had a webinar back in April. There's a lot of artists that are very much in favor of AI, trying to embrace it rather than oppose it, mainly because it can make good work great work. There's a lot of tools that are available that cut down on the administrative or repetitive tasks that are available. So in a lot of ways, AI can be viewed as being very positive. On the other end of the continuum, I think a lot of artists see AI as a huge threat right now, and as potential robbers, stealing their original creations and then monetizing them with no benefit back to the original artists. There is agreement and consensus, however, on the need to start to put some guardrails around AI. AI can be very, very positive, but there needs to be consent, there needs to be choice, and there needs to be recognition back to the original artist, the content that's being used to train some of these AI platforms. And so a lot of the activism in the marketplace right now is really around attribution and monetization, fear of lost revenue, and that's all completely understandable. There is a lot of artists being very vocal about the need to be able to opt out of some of these training opportunities. So if a platform, an AI platform, wants to leverage content for training, an artist should have the right to be able to exclude their content from being used for training purposes. And then finally, there's a fair amount of chatter around the need for data tracking, like metadata and tags on the original work, so that when that work is used either for training purposes or repurposed, from an attribution standpoint, you can trace it back to the original artist and either make sure they get approvals and or they're compensated properly for the work that they initiated. Next slide. And so there's a lot of changes happening right now in the legal landscape, and a lot of this is being initiated around some of the lawsuits that are happening. And so everybody's pretty familiar, I would imagine, with Getty Images. So Getty Images has a pretty profound case in place right now with Stability AI, because Stability AI is one of the platforms that's using content Getty image content to be able to train itself. And so Getty has, obviously their lawyers have a lot of issue with that because it potentially could put them out of business. Similarly, Anderson, artists that are very concerned about Stability AI using their original artwork to train Stability AI and repurpose some of that artwork. And so those lawsuits are pending right now. And it's 50-50 in terms of where it would go directionally. But one thing for sure is it's going to have a profound impact on how the legal frameworks are actually constituted moving forward. And so when you look around the world, the European Union is probably the one that is leading the most in terms of putting some frameworks in place around AI and how artists can be protected. And they've coined something called the AI Act, and it really focuses on right-based protections and transparencies from these platforms when they're using an artist's original content. And then the US and other jurisdictions are exploring similar legislation as well. And I think they'll use the AI Act as precedential and then sort of build on it. And Canada will be closely behind as well. And so some of the trends that we're starting to see, particularly in the legal landscape, are artist-led licensing platforms. And so platforms that will only use content for training AI platforms if an artist actually gets properly compensated. We're starting to see a lot more digital footprints in place, watermarking original work so that it can be traced back from an attribution standpoint. And then Creative Commons style AI usage licenses. And the music industry is a perfect precedent. I'll talk about that in a moment, where some of these types of usage licenses protected the original artists and provided them a royalty stream if their work in fact was used. Next slide. So the biggest question is, how can we as artists protect ourselves? And it's not easy right now because, as I say, the landscape is changing and it's evolving so quickly, but there's a few things that we can do. So the first one is, feels natural and intuitive, but is to register our work with the Copyright Office. And again, if something's tangible and it's being used for commercial purposes, it's fully protected. The second one is doing some tagging to trace our work. So whether it's digital watermarking or metadata, putting a tag in place. So from an attribution standpoint, if our work is either used for training or it's repurposed in any way, we can trace it back to the original owner. The third one, and this one is gaining a lot of momentum right now, AI platforms are being asked to ensure that they allow artists to opt out of having their work used for training data. And I'll cite some of the platforms that are doing that today. It's not everywhere right now, but there's about 5 or 6 of them that are starting to do that. And I think that'll set a good precedent from a legal and ethical standpoint for all platforms, giving the right to artists to be able to opt out. If you do not want your work used to train an AI platform, you absolutely unequivocally should have the right to do that. The fourth one is really about exploring collective licensing or union initiatives. All of us is better than one of us. And so there's power in numbers. And so some of that is starting to shape our voice in the marketplace right now, particularly in Europe. And then finally, be vocal. Advocate for transparency legislation around AI to make sure that all of us are protected. It's really important that we have a voice right now. Next slide. So the biggest question, and again, nobody has a crystal ball, but what's likely to happen next? And this is really interesting. I think the next 3 years, and we're in one of those 3 years right now, like 2025 right through to the end of 2028, I think is going to be pretty precedential in terms of expediting a lot of the legal frameworks that we'll start to see come into place. And so a few things are going to happen. So the first one really is around the courts, clarifying around AI authorship and infringement boundaries. So what's fair game? What does the playing field look like? It's almost like freedom within a framework for these AI platforms or bots to be able to use content. And some of it could be around, you've got to get express consent. You have to give the opportunity for an artist to opt out. But I think we'll start to see more and more of that happening. Next, I think there will be some industry standards that will be adopted, mainly around consent and licensing, particularly as it relates to these platforms' training. So if they are going to use our content for training, then we'll probably end up getting some royalties or some type of attribution and or monetization back to the original artist. Next, there will be a significant expansion of artists' rights through new legislation that's coming. There's a number of bylaws that have been drafted around this right now. They haven't been pivoted into law just yet, but that's part of what's happening in the European Union and the US right now. And then finally, we'll start to see artists gaining a lot more control through tools. So some of the very platforms that are using content, unauthorized content, and raise ethical and legal concerns today, there's a number of platforms that are being produced right now, tools that'll help audit and manage usage of the originator's creative work, which I think is very positive. So AI can be used very positively as well. And so if you look at that from on an annual basis on what's going to happen in each year, so this year, I think we'll start to see some major court decisions based on some of the legal frameworks that are happening right now in the US and the UK that'll set precedent around AI authorship. I think in 2026, we'll start to see some opt-in, opt-out databases for AI training, which I think will be very positive. And then in 2027 will probably be the key year where we'll start to see some global standards around this. And then finally in 2028, I think we'll get a lot more legislative reform recognizing AI-assisted authorship with human input. Like, what does that mean and what does that look like and what are the specifics around that? Next slide. And so there's lots of questions. When I went through this, there's probably a lot more than I've listed here, but I listed 8 questions that I thought were really important in terms of what's going to be solved for over the next 3 years or 4. So the first one, and this is at the heart of the storm, right? Who owns AI-generated content? Can a machine own it? How much human input is really required? And should a new category be introduced, like quote unquote AI-assisted authorship? I think that would be a great way to be fully transparent and authentic, in my own opinion, to have a category that actually recognizes and labels where artwork has either been repurposed or it's been AI assisted. Second question is training AI on copyrighted works fair use? And so if an AI platform is scraping public data and those AI models are taking that data and repurposing it, is that fair use? And if it does fair use, should an artist be compensated? I think obviously they should. And then finally around that, what legal obligations do AI developers have? Ensuring that they follow whatever laws that are in place moving forward around training some of these platforms. Third question is, should artists be compensated when their work trains AI? I happen to think they should. Some type of royalty-like system probably should be in place, as well as an audit system in place to be able to govern some of this. Next slide. Fourth question, what really constitutes infringement when AI is generating outputs? And so how closely does it have to resemble the original copyrighted work? Should we have some form of style limitations around what can be repurposed? Again, some of that, I don't think all of it will be solved, but those are some of the areas that I think will be tightened up over the next 3 years. Fifth question, how can attribution be enforced in AI-generated work? So we talked about meta tags or some form of tagging from an attribution standpoint. That would be really important. But it raises the question around who's responsible for that tagging and attribution. Is it the original artist? Is it the AI platform? Is it the person putting the prompts into the AI platform to repurpose the work? All of that needs to be defined. What are the trademark implications of generative AI? If a logo is too similar, who's liable? That's bound to happen for sure because there's so much replication happening right now. Does a company have the right to sue? And if they sue, who do they sue? And who needs to be fully indemnified? Next slide. And then the final two I thought of is how can artists opt out of AI training data sets? We talked about that a little bit. Like, what is the technical or legal standard to opt out to make sure that it's widely recognized and enforceable? And how should the rights be handled for artists whose work is already in training data? So if it's already, do we grandfather it? Or do we just put a line in the sand and say all work moving forward will need to opt in? Those are all great questions that I think need to be solved for. And then finally, how do we ensure transparency in AI systems? Like, should AI companies be required to disclose where they got their data from to train their platforms? Kind of feels like they should. And then who's going to be the regulatory oversight for this, and what type of penalties or enforcement need to be in place? Really, really interesting stuff right now. Otherwise, it'll become the wild, wild west. Next slide. And so the good news is there's, like we've been through this before, you know, even when you think about major changes that have happened in the economic landscape, starting with the Industrial Revolution, the internet. Now we've got AI, we've got quantum computing coming. And so the best way to start to draft legislative frameworks is to look back on precedents. And so the music industry is probably a great one. And so we're probably all aware of artists stealing other people's songs and then repurposing them. So all these sampling lawsuits happened a long time ago. One example of that is Grand Upright Music versus Warner Brothers. And so that really started to help establish some frameworks and some protection for an artist's original music work. And if their work is being used, they have to grant approvals and they get residuals or some type of licensing protection. Similarly with Napster and digital privacy, you know, that's why we have Spotify and Apple today. And so there's copyright violations that had emerged, and so they need approvals through frameworks. And then finally, this whole notion of the royalty systems. You know, if in fact an artist's work is being used, then there should be royalties paid. And again, the music industry is a perfect vertical to be able to learn from. Next slide. Other industries would include photography and visual art. And so I talked a lot about Getty Images lawsuit today over the unauthorized use of their images in terms of training some of these platforms. That's going to certainly be precedent setting. Getty would go out of business if in fact that wasn't, there were some adjustments in the legal framework. So that's certainly coming. Next slide. And then finally, the film and TV industries, you know, for piracy and streaming distributions. I mean, that vertical artists would have been out of business if some of the changes hadn't started to take place. Deep fakes, which are famous in the pornographic industry and other verticals as well, around the ability to control one's image. And so new technologies like that require legal adaptation and tools to be able to control how content is used. And so I think whether it's music, film, I think all these industries will have a profound impact on how the legal frameworks are set up moving forward. Next slide. And so in summary, I'm very bullish on AI personally. I think there's certainly some legal and ethical concerns for sure, and it's a bit of the Wild West out there right now. But I do genuinely believe that we can coexist with AI. And I actually think if used properly with the tools that are available, as I talked about in our last webinar, I actually think it can make us better. Having said that, precedentially, it's critically important that proper boundaries, freedom within a framework, and legal platforms are put in place, mainly to protect all of us in terms of our original creations. That's for sure. And so those frameworks must evolve to ensure fair use and protection, both in terms of attribution back to the original owner, compensation, as well as the right to be able to opt out of having original works used for training purposes or any other purposes if an artist deemed it appropriate. And then finally, I really do believe that for us to be successful moving forward, and I think I'm really inspired about where AI can help us. I think collaboration is key with those that are designing the technology, the artists that are creating the great work, and the lawmakers that are protecting everybody. And so it's going to be really interesting over the next number of years to see some of this come into fruition. And just before I hand it back to Scott, it's really interesting. I was mentioning to Scott, for those of you that read the Globe and Mail, in yesterday's edition in the Report on Business, there was a really interesting article on a famous painter. It was called the Morisot fraud. I hope I pronounced that properly. And essentially, there were a lot of AI, there were a lot of artists that were actually knocking off the original Morisot paintings and producing their own versions of them. And there's a new AI fraud detection software called Norval that actually can be used very favorably and positively to protect artists' painting. So what it does is it can very quickly analyze a fake and determine that it's a fake by looking at the patterns, the brush strokes, the color palettes, the angles of how the painting actually occurred. And so a lot of these tools are going to come along, and I think they're going to offer a lot of protection for us as well. And so it's a really interesting example of how AI can be used positively to protect all of us as artists. So thank you very much, and I'll hand it back to Scott so we can take any questions.
Thank you, Lauren. Yeah, lots of stuff to process there. So let's get to the questions. I'm sure there are a few. We had one submitted ahead of time, and Lauren, I'm going to lead off with that one. Is there any way, say a website, where an artist can post their work to protect the intellectual property from being harvested or scraped by AI without permission?
Yeah, I thought this is such a great question, Scott. Thanks for forwarding it to me in advance as well. And so the answer is yes. There are some platforms that are available that can protect us all as artists. It's not a perfect world yet, and so they're not bulletproof. But I'll give you a list of some of the ones that I found. And so there's platforms like Pixie, DeviantArt, Content Authenticity Initiative, Spawning.ai, License Symbol, and Glaze. And all of these are platforms that really prohibit AI training. So there's little risk of your content being scraped because they specifically say they will not train using an artist's original content. So you may want to check those out. I'm happy to share those moving forward. That's the first thing. The second thing, and I talked a lot about this today, is that you can add some type of tagging system to your original artwork as well through metadata. And so it's probably wise to put some form of protection from an attribution standpoint so that if an AI platform happens to train on your content, even though they said they don't train on it, at least you've got a tagging system in place. And then a few other things to consider would be to really avoid platforms that do not overtly state that their stance on AI training. If they don't say specifically that they will not use your content or use content on the public web to be able to train, then it's probably a pretty safe bet. But for those that don't, you have to ask the question and you have to get it in writing. And so those are probably the three top things that I would do to protect myself. But there are a number of platforms that are available right now, not a ton, but probably 6 or 7 that you can source that your work will be protected.
Well, it's a good start. Thanks, Lauren.
You're welcome.
We've had a question asked about who has the right to reproduce and share iconography or motifs that are rooted in specific cultural traditions.
Yeah, again, that's one of those questions. So very similar to what we talked about with copyright and trademark law around brand identifiers. It's a very gray area right now. And so that's one of the precedential cases that I think legislators moving forward are going to have to really put some strong language around. It's not well defined today. I'm sorry, I don't have a better answer because I looked at mainly around brand identifiers, and that would be one of them. And so I think those are some of the issues that will be covered off over the next year or two. The European Union, I was looking through some of the legislation in the AI Act. I didn't see anything specifically around Indigenous, but I do know that that's an area that certainly will be crafted moving forward.
Question from George in Lethbridge about the fact that in Canada there's no requirement to register work with the Copyright Office. So what is your recommendation there? Or here? More to the point.
Yeah, exactly. I would strongly recommend you still register it. It's not a requirement today, but I do think what's going to happen is Canada is going to very quickly follow US precedent. I mean, the European Union is doing a lot of the work now around AI, but there's some US legislation that's being drafted as well, and Canada is very closely at the table. So my recommendation would be, and I do that with some of my own work on the strategy side, is that anything that you can do that's going to, particularly if it's going to be used for commercial purposes, that you do get it copyrighted or trademarked, and just have that extra layer of protection right now, even though it may not be mandated. But I would strongly encourage all of us to do
that. Here's another thorny question, and that is the way AI might impact artist resale rights. Right now in Canada, there was almost a law that guaranteed that a visual artist whose work was resold would get a 5% royalty. That kind of, it didn't make it to law because the government prorogued. And now we have a new government, and hopefully that'll come up again. Could AI act as a catalyst for advancing those rights, or might it further complicate enforcement?
Yeah, it's interesting. And these are all just such great questions. And so I don't have all the answers, but I do think AI is going to act like a catalyst. I think similarly what happened in the music industry with Napster, and I think what happened with the other verticals that we talked about as well. Anytime that legislation and or legalities, one party starts suing another party, it usually becomes a catalyst for actually tightening up laws around that particular vertical. And so I do think in this case, it's going to benefit all of us as artists. I do think the original creators will be some form of residual royalty system that'll be put in place. I don't know what that means from a monetization standpoint today, whether it'll be 5%, 7%, 10%. But I do think there will be frameworks put in place that are going to protect original creators, because the issue right now is the repurposed art, if you will, is so close, so similar to the original creations in a lot of cases that I think it's going to upend the entire artistic community. And so I think there will be protection. And to answer the question directly, I do think it's going to help. Especially even the issue with Getty Images right now. They're a prolific brand, very well known, not only within the artist community, it's just a very well known brand. And so I think that's going to set precedent around protection from an attribution standpoint, an ownership standpoint, and certainly from a compensation standpoint as well. So I think it's going to work positively for all of us.
Let's hope so. A question from Barry in North Bay. What about moral rights? Many artists' contracts forbid moral right fakery. AI's ability to deepfake makes it capable of portraying an artistic viewpoint as the exact opposite of what it was. Should this be included in AI legal questions, as it often is in contracts between artists and publishers?
Absolutely. And so when I talked a little bit about deepfakes, both in the music industry, the pornographic industry, a number of other verticals, that's where there was misrepresentation around someone's rights as a person. And so I absolutely unequivocally think that's going to be addressed, because there is precedent. And so, and there's concern. And that's one of the biggest issues around AI right now, because it could replicate and or communicate something on your behalf when it wasn't the original intention as a creator. And so I think it'll put more discipline in place for us as artists to make sure that we build some rhetoric around what we created, why we created, the rationale, what it's supposed to communicate as part of the copyright and trademark component, so that if and when there's a deep fake or someone replicates that image, even if it's off one standard deviation, and it has the meaning of the art is communicated as being different than the original intention, then I think that'll be protected. I really do. And again, because there's precedent.
We had a question from Mary. What is the cost of registration in Canada? Mary, could you expand on that? Because I'm not sure what you're referring to. If you're talking about registering, say, a piece of music, if you're a member of SOCAN, which is the Canadian Music Copyright and Registration Company, there isn't any cost to register a piece of music, but by the same token, they don't ask for specifics like a piece of sheet music or digital equivalent. So for example, when I register a piece of music or want to make sure it's protected, I go to the U.S. Library of Congress and register it there, where I think it's less, it's around $75 US to register, or 50 US, which would make it 75 Canadian. I don't know if that answers your question, Mary, but, she has asked, she wants to know the cost of registration for writing and websites. I guess for a website that would protect someone's content, one of the ones that you mentioned. Any idea what the cost is to put your?
I don't know. I'm happy to take a look, Scott, and I can send you a note you can share back with your group.
Okay.
I'll go online on a few of them and I'll see how much it is.
Great. Thank you. Thank you. We've had a request from Leah to put a or get a transcript of the chat and the Q&A. Certainly, the chat we can post with the video, so we'll do that for sure. Patricia wants to know, artist resale rights. She's been told will be in the next Copyright Act, and this is from a former senator, Canadian senator. So I think Patricia definitely knows what she's talking about, and thank you for clarifying that, Patricia. Uh, and you know what? That's all we have in terms of questions. The chat, as Leah requested, has all kinds of really good data and comments and thoughts and explanations. So we will make that available along with the video, and we'll be doing that in the next few days. So I just want to say thank you so much, Lauren, for this. This has been great. As usual, we really thank you for your time and your expertise, and for making this possible today.
And Scott, to you and your members, thanks for having me. It was really enjoyable and just a really interesting topic. And I really do believe it's going to be a little bit contentious over the next little while, a little bumpy, but I think we're going to end up on the right side of this. So
contentious, you think? Really?
Just a little bit. But thanks for having me. I appreciate it.
Thank you, Lauren, again. Thank you to our series sponsor, TELUS, again, and most of all, thank you for being here today. We will be posting a video of the webinar along with the slides, probably early next week, possibly sooner if I can get it up sooner, and we'll let you know when it's available. Just wanted you to know that the previous webinar we did with Lauren in April is posted on our website. It's also about AI. We also have webinars on public relations, art and neuroscience, preserving the mind, copyright, social media, artistic legacy preparation, identity theft, fraud prevention. They are all posted online and all available for free anytime you want to have a look. So you'll find it at canartnet.ca, and just go to the click on the webinar function. So thank you again for being here today. I hope you've gotten something out of it. I hope it helps you, and I hope it protects you and your work in future. And in the meantime, thank you again for being here. We will be doing a webinar in the not too distant future with the Canada Council on their new platform. They're still trying to get that in place, so it's not quite ready for public consumption, and therefore they're not ready to talk about it. But as soon as it is, the Canada Council and CAN will collaborate on a webinar for that. So until we meet again, be safe, stay healthy, stay happy, and have a creative day.